Hello, legal-minded friends. In today's video, we are going to get inside a juror's mind because Aidan Kearney interviewed a juror from the Karen Reid trial, and it is pure gold. Every lawyer's dream is to understand what the jury is thinking. So let's get started.
First of all, do you confirm that it was a 12-0 vote for acquittal on murder and leaving the scene of an accident?
That is correct. So
Okay.
that was what the entire group agreed upon. That being said, it was confusing because we didn't have very clear direction on if it was all or nothing. In other words, if all three convictions had to be 100%. So that's why the response that it was that we were continued to need to deliberate because it was not clear on that one charge. So the one charge that we were not very clear on and not everybody was in agreement with was essentially the manslaughter charge, involuntary manslaughter. So that was the one that we were not clear on. But the other two charges, which was essentially second-degree murder as well as leaving a scene of an accident, was very clear. We all 12 agreed that was not the case.
Here's a thought. Jurors should acquit, even against the judge's instructions. If exercising their judgment with discretion and honesty, they have a clear conviction that the charge of the court is wrong. Who said that? Let me give you a hint. The author is a United States founding father and played a key role in securing America's independence and helped to push through the American Constitution. And whenever we try to interpret what the founders meant, we look to their views and writings. So, what do you think Alexander Hamilton meant when he wrote jurors should acquit, even against the judge's instruction? Let's pause there and find out. Was the jury confused about the judge's instruction?
You and one other juror wanted to ask the judge, Judge Kearney, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently of each other
individual charge,
versus,
right? Yeah.
So that was the question. It wasn't necessarily.
Yes. Right. So acquittal, conviction. Yeah. So but you wanted to ask the judge, are we allowed to come to a decision on two of the charges and hang on the third?
Okay, so what we heard is that the jurors said they did not know if they could make a decision on each, and I believe he used the word conviction, on each convictions, which is odd because a conviction is after you've been found guilty in the courts. So, and what we're going to hear in a second, I'm going to play just a little clip because the judge actually refers to the indictments, which are the formal charges, and that's why the juror was corrected. They are charges. So let's hear that because the answer is in what the judge says.
12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment.
So Judge Kearney clearly says if you have any reasonable doubt as to any essential elements of any indictment, you must find the defendant not guilty. I go through this in a few videos where I thought where the confusion was and how the judge just declared a mistrial before giving some considerations to options before letting the jury go and deciding a mistrial. On the day that the court abruptly ended, the defendant had filed a writ of habeas corpus in the Norfolk Superior Court to have this higher court review the SJC's recent decision saying the trial judge was correct in deciding a mistrial. Now, from my research, it indicates that this higher court will be concerned if a judge's decisions are made in haste, not going through the options prior to calling a mistrial. That would violate constitutional rights. This court has the power to dismiss all charges if the SJC got it wrong when they decided the trial judge got it right. So I hope that makes sense. Going back to the juror, what I understood him to say is that the jury was confused as to could they send all of the verdict forms back if they weren't decided unanimously on all of the charges or the indictments. Why didn't they just ask the court? Well, maybe they expected the court to do something before they, would do a mistrial. And let's hear what the judge had told them she would do once they sent in a note.
Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers.
Okay, so what we're going to do now is jump forward to when the jury had been deliberating for a while and they came back with a note to the court. And so, after they called everyone back into court to hear what the jury had to say, let me know if you think the judge did what she said to the jury when she was giving them instructions. Remember, she said she would read the note to the lawyers and consult with them. So let's have a watch to see if this happened. So that's what we're going to watch now. They've just called everyone back into court and the judge is going to read their note. Let's see what happens, because maybe this is where the confusion was. Maybe the jury thought something else was going to happen. And does it happen? Let's have a watch.
Jury. Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Kearney, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
So within 5 seconds of reading the note, the judge declared a mistrial. She did not do what she told the jury she was going to do, that she was going to consult with the lawyers. The jury did obey the judge's instructions by not giving a numerical count of what they had decided. So had the jury disobeyed the judge's instructions, because that's what their conscience was telling them to do. Like if they had just said, let's just hand in the slips. We are 12-0 on these two charges, two indictments, and we're hung on the one, let's just hand them in. That's what we have to do because that's what we've decided. But did they expect the court to, give them the okay to hand the verdicts in? And that's what the habeas corpus filing was about, when the defense is now asking the higher courts to look, was Karen Reid's constitutional rights, violated because the judge didn't do everything in her power to ensure a verdict was reached in open court, because the jurors did not hand back the jury slips. So, should they have just done it anyway and disobeyed the judge's instructions, because that's, what they had decided, going back to the original phrase that we heard. One of the arguments the defense is making, that there may have been, a viable alternative to a mistrial, and that would have been to, ask the jury to hand in their verdict slips with the decisions that they had come to, because they clearly said some of them were deeply divided and some of them weren't. So that to me suggests that some of them wanted it and some of them didn't. But it would have definitely answered to the confusion, wouldn't it? And if I'm understanding the defense's petition to the higher court, they're saying that the existence vel non-manifest necessity, which is, I believe, a Latin term meaning they didn't have a choice between something, so something happened or it didn't happen. And they're trying to say because the manifest necessity didn't happen, they didn't really have a choice about consenting. And that's when they said that if a mistrial, was occasioned by a manifest necessity, then the question of consent becomes immaterial. So, like some might think, well, why didn't they just object when the judge said there was a mistrial and dismissed the jury? All of that took 15 seconds and the jury was leaving the room. But, could the defense say, excuse me, we object. Why didn't you question the jury? And they're saying if the judge would have done, what she should have done by using all viable options to question the jury to see if they had a partial verdict, then they wouldn't have to have the need to consent, because that becomes immaterial. So, I don't know. That's the way I understand it, but we'll have to see how the High Court decides this. So the question is, from a constitutional point of view, regarding the Fifth Amendment, was the defendant put in double jeopardy when the court didn't follow through with viable options and was going straight to a mistrial, a violation of Karen Reid's constitutional rights to a fair trial and not putting her in double jeopardy. What's your thoughts? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power. meaning if you know something, you can make decisions that are right for you.